What a twist to end on. Just when the landlord thought he could walk in, demand higher rent, and collect a double security deposit, the judge shut it down instantly. This moment is a perfect example of how power shifts inside a courtroom. 1 second, someone thinks they're in control. The next, the law steps in and flips the entire situation upside down. And that's exactly what happened here. David Sowolski entered court claiming his tenant, Lisa Laro, owed him thousands in unpaid rent, $3,200 to be exact. On top of that, he demanded a brand new $2,400 security deposit, arguing that since he had just bought the property, he could set his own rules. But the judge wasn't buying it. Not for a second and just minutes, the foundation of David's case began to crumble. Not because of emotion, not because of sympathy, but because he failed to follow basic landlord-tenant law. And once those mistakes came to light, everything changed.
Lisa Laro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawalski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file?
I wanted, I wanted a 1.5 month, $2,400 security deposit. And now she owes $3,200 in back rent because I took over. What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid it.
Let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
we had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you tell her that?
24
No,
hours
sir.
to think about it, and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, I for her to stay there, I wanted.
No.
Okay.
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
Yes, sir.
And in that complaint,
Yep.
you basically indicated that, well, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true. And
I originally offered her, sir, $1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's say a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent, yet you filed a complaint that says that the rental rate is 1,600. Frankly, sir, that's false.
Okay.
Then you don't say, you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel.
Well, hold on, just hold on, ma'am, just
What
take a
I,
breath, please. All right. How much did you pay as a security deposit?
Was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
a.
I
And he told me he had no
don't,
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant, which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third
Yes, sir.
on my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the 1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit.
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my previous.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof. But I don't see anything in the beginning of this that you did that's right at all. Have you asked the previous landlord if he has her security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are going to end up getting sued. So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights.
Well, because if she put it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not paid rent, not knowing the circumstances, not sure that was any of your business, but that okay, you took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay. I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out. to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
Thank you, sir.
Have a good day, ma'am.
1 p.m., November 7th.
1 p.m., November
The
7th.
collapse was swift and brutal. No written notice. No legal rent increase. No right to demand a second security deposit. Strike after strike, the judge dismantled David's claims piece by piece. When you buy a property with a tenant already living in it, you don't reset the rules, you inherit them. The lease transfers. The deposit transfers. The responsibilities transfer. And ignorance doesn't erase any of it. Then came the warning that changed the tone entirely. Because this case was filed under penalty of perjury, the judge reminded David that false or reckless claims could lead to serious legal consequences. That wasn't advice. That was a warning. And when David tried to back out, attempting to withdraw the case and move toward eviction, the judge didn't let him escape so easily. Instead, he kept the case alive, ensuring Lisa had the opportunity to defend her rights and potentially file her own claims. That's courtroom authority at its strongest. Not loud. Not emotional. Just firm, controlled, and grounded in the LAW. Oh, now the question is yours to answer. Was this a careless landlord who rushed into ownership without understanding the law? Or was this a tenant who refused to be bullied into paying money she didn't owe? Cases like this remind us that the courtroom is the great equalizer. Money, property, titles, none of it matters when you stand before a judge. What matters is the law, the evidence, and whether you followed the rules. And this judge made one thing crystal clear. Ignorance of the law is never an excuse. Drop your thoughts in the comments. ChatGPT can make mistakes. Check important info.